Palworld is Pokemon with guns. We can all agree on that, right? The similarities are massive. Pals are basically Pokemon. You can catch your pals with a Pal Sphere, basically a Pokeball. You have a Pal Deck. This is a Pokedex. The list goes on. That being said, the current dispute between Palworld and Pokemon isn't even close to the first time that there has been an accusation of blatant copyright infringement from one game to another. There have been plenty of times where video game developers have been accused of skirting the line, or running straight through it, when it comes to stealing another company's ideas. So, let's take a look at 5 times where video game companies blatantly stole from another developer. Let's start with one of the titans of the industry, Nintendo, suing a developer for infringement of its patents which, honestly, are kind of broad to begin with. Colopl is a Japanese developer which, according to its website, specializes in mobile, blockchain, and consumer games. I don't know what a blockchain game is, but I'm sort of terrified. Now, to be clear, this is not a small company. They have a variety of major games on the market and have done development work for Disney, so suffice to say, they should know their way around intellectual property. Anyway, the game in question was the Shironeko project, and sorry if I mispronounced that. This free-to-play mobile game is an action RPG, one that is controlled via touchscreen. Players could launch attacks via the Punakon attack, in which players would drag their finger across the screen and tap on the appropriate spot to attack an opponent. And that is one of 5 patents which Nintendo said violated their intellectual property, noting that they had patented similar technology via the Nintendo DS wrist strap. This, in turn, led to a lawsuit of increasing expense. First, Nintendo sought $42 million in damages, then $47 million, then $92 million. Yikes. Colopl, realizing that they had a major problem, settled the lawsuit for $30 million. They also changed the input controls to avoid future violations. This is kind of an interesting one, because it shows how massive conglomerates, Nintendo, can get patents on what seems to be relatively common software. Can you really patent a controller scheme? Apparently, yes. Other times, the patent violations are much more clear. Such was the case with Tetris Holding versus Zio Interactive. Everyone knows Tetris, one of the most popular video games of all time. In fact, Tetris is so popular that, well, some folks tried to blatantly rip it off. Enter Zio Interactive. Founded in 2009 by Desiree Golden, Zio attempted to get the license rights from the Tetris Holding Company, the company co-created by Alexis Pajitnov, the creator of Tetris. Anyway, the Tetris Holding Company said no, and Golden decided to try to figure out a way around international property law and launched the game Mino. Mino was described as a game similar to Tetris, but different enough, or so they hoped. In the game, Tetramino blocks form lines that must be cleared. Mino, however, had power-ups and additional game modes in a clear attempt to differentiate itself from its inspiration, Tetris. The Texas Holding Company was, shall we say, less than pleased. They filed a lawsuit in 2009 claiming that Mino infringed on their intellectual property. So, here's where things get interesting. Copyright law in the United States held that game expression could be copyrighted, meaning how a game was displayed, but that gameplay elements couldn't. The question in this lawsuit thus didn't pivot around a Tetris-like game, that's legal, but about whether or not Mino was too similar to Tetris. The court ruled that it was. In her ruling on the case, Judge Freda Wilson noted that a slew of gameplay elements, including the grid pattern, shadows falling where Tetris pieces landed, and the display of the next piece to fall, were present in both games. As a result of all of these elements, Mino was too similar to Tetris. Judge Wilson found that the average person would have a difficult time distinguishing between the two games, given the overwhelmingly similar elements. Thus, the game violated Tetris's copyright, and Judge Wilson entered an injunction to stop Mino from being sold. The ruling was not appealed, and that was the end of Mino. By the way, this is not the first legendary game that was so good that another company saw it and thought, hey, I know, I got a brilliant idea. I want to do that. Enter KC Munchkin. We all know Pac-Man. Our little yellow pellet-eating friend has sold more than 73 million copies in various iterations, making it one of the most successful video game franchises of all time. Of course, that has not gone unnoticed. Enter KC Munchkin. Released in 1981, this maze-like game features KC Munchkin running around a maze and eating pellets while avoiding ghosts. That kind of seems lazy to me, I don't know. KC Munchkin came out for the Magnavox Odyssey 2 in 1981, a year after Pac-Man first hit the shelves as an arcade game, but a year before Pac-Man came out on any home console. It is also worth noting that Casey Munchkin was released by Philips, not exactly a small name in the electronics business at the time. The massive similarities between the two games led to a lawsuit from Atari. Interestingly enough, the first lawsuit actually failed, with a US District Court ruling in Philips' favor. There were at least 9 substantial differences between the two games, including Casey Munchkin having the ability to create mazes, a fewer amount of pills for Casey to eat, and a random maze mode. None of these features were present in Pac-Man. However, Atari appealed, and they won the next ruling. The court noted that the two games still had substantial similarities, at least 22, and said that the differences between the two games, quote, only tend to emphasize the extent to which Casey Munchkin deliberately copied the plaintiff's work, end quote. Ouch. With Casey Munchkin off the market, Philips released a new game called Casey's Crazy Chase, which pretty much seems to be a clear shot at Atari. In the game, you play as Casey, racing against a character called the Dratapillar, which looks an awful lot like the arch enemy in Centipede by Atari. Is this the first example of a developer creating a whole game for the purpose of trolling? The world may never know. So, here's another interesting one, albeit with the most random game ever. Meet Voodoo Games. Based in France, Voodoo Games is a massive developer. The company has launched more than 200 games, with 7 billion downloads and more than 150 million active users. Not bad. The games really run the gamut, but they are the kind of games that you play while putzing around, waiting for something better to come along. They include Helix Jump, Paper IO, and Wood Turning, all of which can be categorized as hyper-casual games. So let's talk about wood turning. You get a block of wood, the block spins, and you complete customer orders by turning the block into various shapes. The app page for the game describes it as the best wood turning simulator. All right. Anyway, Ric Games and their developer, Hero Games, created their own game, Wood Shop. Now, as we've seen, you can't trademark an entire game genre. However, you can trademark ways in which the genre is expressed. And according to Voodoo Games, that's where Woodshop crossed the line. Woodshop was originally its own game, but then an update came out that Voodoo Games said it was too similar to wood turning. Those updates included the ability to make real-world shapes, polish the wood, and paint it. Voodoo Games went to court in Paris, where it sued Ric Games and Hero Games. The court found in Voodoo Games' favor. In its September 2020 ruling, the Paris court found that the games were too similar. Ric Games was ordered to pay Voodoo Games 125,000 euros for, quote, unfair competition and parasitism, end quote, as well as to publish an announcement of the judgment in 3 papers of Voodoo Games' choice. In praising the ruling, Voodoo's lawyers noted that they hoped the ruling would be precedent-setting in the hyper-casual gaming space. A bit ironic, given that other developers had previously accused Voodoo of ripping off their games. Incidentally, Ric Games had just been purchased by Zynga a month before the lawsuit was decided. Zynga bought the company for $168 million. So congrats on that purchase. Or something. Let's turn our attention back to the big guns. In the early 1990s, Sega was riding high. Their new system, the Sega Genesis, was eating into Nintendo's market share. In fact, for a brief time in the early 90s, Sega was the industry leader. Now, if you're a third-party developer, publishing games on the Sega wasn't as easy as you wish it was. As a way of wringing more profits out of developers and protecting the quality of their own system, Sega, like Nintendo, required developers to pay for game licenses that would allow the developers to publish games on the Sega platform. This was obviously not cheap for the developers, and according to some, it could as much as double their costs. Accolade was primarily a computer games developer that published successful sports games, including Hardball, Test Drive, and the Jack Nicklaus Golf Series. The company wanted to publish some of their computer games on the Sega, but ran into an expensive problem, the Sega licensing system. Among other things, the licensing system came with a code. Developers armed with this code could create games that would run on the Sega. No code? No games. So, Accolade did what any tech-savvy teenager would do. They reverse-engineered Sega's copyright code, developing a way to get around the licensing system and sell their game. Sega, unhappy, sued, and won, at least at first. In 1991, Sega won their lawsuit, having successfully argued that Accolade violated their copyright when they reverse-engineered their code. Accolade argued, unsuccessfully, that the reverse-engineered game was fair use. Fair use is a legal doctrine that basically says copyrighted material can, in some circumstances, be used by other parties. like on video game videos. Anyway, the judge issued an injunction against Accolade and ordered them to recall their game. Accolade appealed, and this time they won. The Ninth Circuit of Appeals in the United States ruled that the games were original content, and that the reverse engineering of the games didn't diminish the profits reaped by Sega. By the way, Sega then appealed this ruling, and the case was finally settled, with Accolade becoming an official licensee of Sega and thus able to sell their games legally. Of course, while the injunction had been in force, Accolade estimated that they lost as much as $25 million. So, what is the moral of this story? I honestly don't know if there is one. Sometimes games can be copied, other times not so much. But there is a thin line between inspiration and theft. Finding the right spot on that line? Honestly, sometimes it just comes down to luck.